should stand, looking at it from like a psychological contract point of view. But one of the things you said I was curious about, and this is probably something to do with law, in the case of the sailors where somebody didn't turn up, one of the crew members wasn't there, so they had a potential promise of something if they got the ship back, and then that was overruled as adding extra value. Surely,
as not adding extra.
Yeah, as not adding extra value. Surely the value was the cost of labour of the missing sailor.
The value?
The value was the cost of the labour of the missing sailor.
Yes. But the employee is actually under the duty to work for their employer. So what more have the employee has actually done more than what the contract is asking them to do?
Okay, so if say you only had 2 employees,
yes.
The 3rd employee was absent and they worked 40 hours a week, and this sailing took a week, then each of those employees have contributed 20 hours of work extra. Perhaps they're doing 60 instead of 40.
If they have contributed more hours than they ought to, there's a different matter. There's a new benefit and detriment here.
Right.
But in this example, the employee, all what they've done is their duty to take the ship back. So there's no extra hours or so forth. It's just a normal duty that they are ought to do.
So there's no impact of the missing person?
Well, they have to work, let's say, harder, but that's still under their duty to work harder in a situation where it might arise.
Right.
So the employee is always required to do their best towards their business as a whole and to their employer.
There's already a contractual obligation.
Indeed, there's an implied obligation to obey and to act to their best.
Danny.
Following on from that, surely the employer can then just say, well, we don't need that person, that's redundancy. We're going to save the money that way.
Yeah, you can work harder.
Well, the person who hasn't turned up for work, if we manage to sail the ship home without him, no one else has put in any extra work, what value has he added to my ship?
Nothing, get rid of him.
That's a separate issue to the promise itself.
Yeah.
Shall I answer that? They have to follow a certain procedure when it comes to redundancy, basically. They have to show why he's redundant and so forth. Yeah. So basically it's not just a clear cut. Yes, he might argue that, but he has to show a real reason for making somebody redundant. Okay. Yes.
Perhaps the sailors should have argued that, I don't know, if he had a very specific job, they all have a very specific job, and they're having to do an additional task that's different to their normal tasks, then you would have thought that would mean that they're doing someone else's job. Like, if, for example, if you do a work to rule type thing, you would say, well, I'm not doing that because it's not in my contract to do that, so therefore, you know.
Yes.
But anyway, that's
been argued. That's been argued. Sometimes the employer has. I try to be as to summarize the case as much as possible. Yeah. Of course, the employer has a duty. The employee has a duty to cooperate. The employer might sometimes he has a specific power to relocate and change tasks sometimes within reason, of course, for the interest of the business. He can't say there is different cases that support that the employer has managerial prerogative power to change and manage his business to run smoothly, and the employee should cooperate with the employer in that relation. My argument here, just to sum it up, my argument is that any promises made by the employer, that constitute benefit to the employee, more right, more benefit, better policy, and so forth, that should be honored. First, because the employer has practical benefit. He can have a better staff, more active, loyal, etc., etc. The employee has relied on such promises. It's under the contractual relationship between the employer and the employee. So there's a duty, there's a contractual relationship where it exists. So you can't tell me there is no legal intention unless the wording says otherwise. So the employee has the right to assume there's a legal intention there. I'm also arguing that public policy prevents the employer from the public policy support the expectation between the employer and the employee. Therefore, the promises made by the employer should be honored unless enforcing such promises will constitute to danger, disastrous consequence to the business. If I fulfill my redundancy, for example, policy, that could constitute a danger to my business, that could undermine the interest of my business. And here I'm borrowing something from the public law. This is still under, actually, revision. Colleague in front.
Yeah. What about if the employer denies that unilateral promise? How can the employee prove that?
Yes. That's a difficult question. Very excellent. Now, any promises can be made orally or written in a document. That document doesn't always have to be contractual. As I said, manuals and policies, etc., they are not always, collective agreement, they are not always binding. Certain provision can be binding, other provision could not be binding. For example, opening and closing out and so on. My argument when you deal with contract law, you're not dealing with proofing the promise. This is not my area of study. This is for the judge to believe who is telling the truth. I am only arguing if the judge believes that the employer has made such a promise, what is the consequences? So proof is totally different. It's nothing to do with me.
There's a piece in the paper today about a dispute in Scottish football.
Yes.
There's a young player that's become freed from his contract, and a club announced that he was to join them. And that got an immediate response from another club, who was Livingston, I believe, who said, well, no, he's got a pre-contract agreement to join us, an oral agreement. So does this work for the employee's promise to an employer as well?
Yes.
Rather than employer down?
I won't be able to answer this. I think I need to have a full picture. But I can just give you the principle. First of all, oral or documented promise is exactly the same thing. They should be treated. There's no preference, as long as you can prove that he has said what promise he made. Once they have the offer, acceptance, consideration, and intention, that's it. This is an agreement. Said, written, no difference whatsoever. So the consequences there, if there's a contract, pre-contract or a contract, I would say that it has to be a contract that the employee promised to work and there's an acceptance. However, we need to understand as well that the employee can leave a job. There's nothing to restrict the employee from leaving a job to another job, provided that he gives the agreed notice a week or so. And it's very hard for the employer actually to sue the employee, because what is a week notice worth to the employer? It's not much benefit.
Yeah, I'm just one of the interesting things that comes up from this is to me anyway, is it's a real challenge, I think, for you, in the extent to which the kind of the jurisprudence approach that you're taking can actually engage with or get at the heart of what are actually quite tacit and implied kind of often. I mean, you've talked a lot about some of the formal documents, about company documents, collective agreements, and handbooks. And of course, as you say. But a lot of what you're saying, well, and I think Lynn mentioned about psychological contract, is these promises are often really difficult to disentangle in terms of trying to identify how and when they were made and the details of them and things like that. So it does seem to be quite one of the things that struck me from your work is just how much of a challenge it is. And I just wondered if you were addressing that in your research about the sheer challenge it's taken.
Well, I think it's the beauty of it. This is very challenging. That's why I love my topic, and that's why I enjoy it the most. It's definitely challengeable. That's why I also refer to the US. Of course, 20 minutes you can't really go through it. It's easy. But that's another approach that I'm borrowing other jurisdictions which is similar in their common law tools. They share the same tools with the UK. They have other solutions to the problem of binding or non-binding promises. But if I can go back to, if I understand the question, is the challenge actually related to find whether this is a promise or already exists in the document? If we're looking at whether there is a promise already or not, there's a document that maintain promises. So you're not asking about proof, is that correct? You're not asking.
Not such a question. It was more just
more
of an observation.
No, I think the question is essentially where the boundary between binding and non-binding is.
Yes, indeed. And that's the
relationships that are complex relations, as you know.
Yeah.
But bear in mind, the judge has to decide.
Yeah.
So there has to be a principle, and that's essentially what this work is.
Yes. And that's why I said I wanted to achieve a coherent approach to such a question.
Yeah.
How can a judge actually? Is there a set of principles that that can be coherent throughout, so that the court can actually apply, and we can understand once this is made between the employer and the employee, then we know that the consequences will be binding or not binding promises.
And the law hasn't got an answer.
Okay, probably time for the final question if anyone has one. quick question.
It's a, I don't know what the in this circumstance, you know, what would be the likely situation. But I had a job previously where it actually referred in the contract to the handbook. So in the contract it would say you will abide by the policies as shown in the handbook. So it might be like dress and like what you wear and your behaviour within the establishment and stuff like that. Would that be seen as a binding promise, or is that something that could be withdrawn?
Can I make two distinctions here? First of all, most contracts will refer to your manuals, and that's where my thesis will come. Okay, so you refer to the manual. Is it binding as a whole? The answer is definitely no. One, if the employer says, I want you to dress with a tie, but a year later they said, okay, we don't want you to dress with a tie. If it's a binding promise, you say, well, I want to dress with a tie, this is what I understood to be a binding promise, I accepted your offer to wear a tie. But then this is not a binding, the employer will argue, but this is part of my managerial prerogative that I can change certain things. So that's where a part of the manual is not actually binding. When it becomes binding, in my discussion, once I offer you something that you can rely on, benefit, rights. This is where I can argue, but this is making some benefits and some rights. Money issue, policy issue, how to dismiss somebody. The statutes of the UK or the Act is saying you have to follow 1, 2, or 3 or 4 steps when you dismiss somebody. Okay, my policy, the employer's policy is saying, okay, but I would like also to add the 5th, the 6th, and the 7th step, so I'm actually enhancing the policy. Can the employer draw back and say, well, okay, I only want now to follow the statute, not the one I enhanced? No, my answer is no, because first, it's giving the employee a benefit, the employee relied on that benefit, it's giving you a practical benefit by actually having a better stuff, and maybe that persuaded me to work for A company rather than Z company because of that policy. When it comes to managerial prerogative, it's different, opening hour, closing hour, dress code, and so on. So we need to make a distinction between a promise that is capable to be binding, a promise which is not capable to be binding. And as Barry was saying, there is no clear answer yet in law. I'm hoping that, well, I'm definite that I will find the answer.
That's the right thing to say. Okay. Thank you very much. Okay, we'd better move on then to Lynn. Excuse the sort of overheated commentary from the sports ground.